So first off, welcome everyone to the wonderful Hall of Service here at the American Red Cross. This room is a very historic room. This building was built in dedication of World War II, and there were many American Red Cross volunteers, everyday citizens that served and provided humanitarian services right here in this room ever since World War II. It's a very historic room. It's fitting that we're here today to talk about other humanitarian efforts. My name is Kobe Langley. I'm the Senior Vice President for Service the Armed Forces and International and Humanitarian Law here at the American Red Cross. On behalf of Gail McGovern, as well as Bonnie McElveen Hunter, our President, CEO, and Chairman of the Board, we welcome you to the American Red Cross. First off, I want to thank our sponsors for this event. Thank you to ASL and Human Rights Watch, Washington College of Law, ABA Center for Human Rights, and Human Rights Watch. Also, I want to thank our distinguished panelists, bios of which are on your table, Juan Méndez, Alberto Mora, and Sovcik. Thank you for coming. I'd also like to thank the ICRC for their groundbreaking and timely report. A copy of each is on your tables today. It's an honor and privilege to lead these efforts for the American Red Cross, mostly because of my own personal experiences in this field. And I wanted to share a couple of those with you since this is a new audience to me and a new responsibility. In 2003, I was called to mark and protect a suspected mass grave site in southern Iraq. I was an Army JAG officer assigned to the 82nd Airborne Division. The unmistakable decaying cloth of a young child's sweater was the first of many horrific images and experiences from my time in Iraq that would never leave me. It was also an undeniable reminder that while our enemies would have little regard for protecting the humanities of others in war, we as American men and women in uniform had a solemn obligation to hold ourselves to the highest possible ethical conduct. The world was watching. I spent the next year of my life working to ensure that our men and women in uniform are fully prepared to adhere to the laws of armed conflict and Common Article 3 of the Geneva Conventions that separate us from so many of our enemies. It makes us stronger as a nation, and it was a formative time in my life and brought home the importance of this mission for all of us. My job was a difficult one, to train hardened and highly disciplined killers to balance their aggression and celebrate identity as door kickers and trigger pullers, to balance that with thoughtfulness. The thoughtfulness of a war ethos that incorporates all aspects of warfare, including their limits. We were largely successful in these efforts. However, we were one of many military units that struggled daily with practical implementation of the laws of war. Many succeeded in striking this balance, and others did not. Those failures were visible reminders for all of us of who we are, who we were, and who we want to be. Also in 2003, while working in southern Baghdad and al-Rashid district, we were informed of the death of a detainee in southern Iraq on an outpost that was being managed by the Marine Corps Reserves. The gentleman's name was Nagim Hatib. Mr. Hatib had 6 broken ribs, had suffocated from a broken bone in his throat after being dragged outside by his neck, and died. 8 of the Camp Whitehorse personnel that were responsible for this event were charged with crimes, including negligent homicide. The event at the time was widely regarded as one of many significant and troublesome deviations from international norms of humane treatment of detainees over the course of the past 15 years. This was before Abu Ghraib. Some of these events were committed by our U.S. service members and some by our allies. Many in our humanitarian community would say that it is our national and indeed our global sentiment that shapes the environment in which these horrific acts spring. This is what I like to call the pot of indifference and the stew of callousness and disconnectedness to human suffering that is not our own. According to the most recent ICRC report, that pot is full. The stew is thick with new and hardened elements of apathy. The rise in global acceptance of violations of internationally accepted limits of war must be met head-on, and it must be fought through education and information for all of our citizens. Since the founding of the Geneva Conventions, the American Red Cross has understood the importance of educating the public and the role that it plays in maintaining a steeled resistance to compromising ethics. It's worked to educate all Americans on the rules of humanity in war and help to lead the fight to prevent atrocities that target the weak and the defenseless. All free nations have signed on to these rules, and they've been there to guide American military operations around the world for more than 100 years. Today, nearly 15 years after that formative experience in the sands of Iraq, I'm honored to work for the organization that helped to craft these timeless rules of humanity, the Geneva Conventions. Both I and our international humanitarian law experts, led by Christie, we're proud to embrace a new era of education and dialogue with our fellow Americans. Our new efforts will begin with a fundamental question. Who do we want to be as a nation at war? And how can this team and everybody in this room and the American Red Cross help all of us get there? I can promise you this, we will not shrink from our obligations regardless of the size and scope of the responsibility. The stakes are too high and the consequences are too great. We must do our very best to educate as many as possible on the fundamental principles of humanity found in the Geneva Conventions. Here are some of the things you can look for. We're going to start through monthly IHL trainings here at our national headquarters building in Washington, D.C., a monument to wartime reconciliation. We'll also be pursuing advanced IHL lectures and discussions of pertinent and timely topics, of which this is the first. You can expect videos and special events with international humanitarian law experts from around the world, and much more. For over 100 years, the Geneva Conventions and the rules have successfully protected our troops and the civilians from fighting overseas, and those returning from home from the dangers of modern war. Today, the rules of war are being challenged across the world, yet they remain the world's best hope for protecting the humanity and dignity and rights of our troops and all victims of war. As standard bearers of the Geneva Conventions in the United States, we will never falter in this obligation, and we must never wane in our diligence. Make no mistake about it. Today, there is a young soldier and there is a young civilian somewhere in the world who's relying on us to get it right. We're the American Red Cross, and we're not going to let them down. So we look forward to starting these new efforts with this forum, a topic that many are speaking about, but few are taking responsibility for. Today is our time to embrace our own responsibility in meeting the tasks that are expected of us as humanitarians, educators, scholars, and defenders of humanitarian ideals. It's our responsibility to defend these ideals in the most challenging and dangerous human experience that we call war. So thank you all for being here. I look forward to these fantastic and informative discussions. Christie.
Thank you so much, Kobe, and we're very excited to now be a part of our Services to the Armed Forces team here at the American Red Cross, and very excited to be hosting this discussion today on a very timely and important topic. So just as a few housekeeping notes, there are, as you've seen behind me on the screen, we are using the hashtag Rules of War if you want to send in any questions or comments during the event today. You also have note cards on your tables, so if you have questions that arise during the conversation, we will have quite a bit of time at the end for Q&A with the audience. So fill those out, and we'll have some volunteers circulating around the room to pick those up, and we'll give them to our panelists here. We do have restrooms located in the back of the room to my left, and so if you need to get coffee or food, please head back that way. You do have a copy of the bios listed on your table, so I won't go through the whole list here because they do all bring such a wealth of experience and expertise to this topic, but I will just note a few highlights about our speakers today. To my immediate right is Juan Méndez, who is a professor of human rights law in residence at AU Washington College of Law. And he served as the UN Special Rapporteur on torture and other cruel, inhuman, and degrading treatment or punishment from 2010 until just this past fall in 2016. We also have Alberto Mora at the far end, who is a senior fellow at the Carr Center for Human Rights Policy at the Kennedy School at Harvard University. And beginning in 2001 as the General Counsel of the Navy, he led efforts at the Department of Defense to oppose Bush administration legal theories that allowed harsh interrogation tactics at Guantanamo. So we'll be talking a bit more about that today. And then finally, we have Annie Sovcik, who is the director of the Center for Victims of Torture, the Washington, D.C. office, where she oversees the organization's policy and advocacy efforts dedicated to healing the wounds of torture and ending its practice worldwide. And she has a long history of serving as an attorney on these issues at Human Rights First, Lutheran Immigration and Refugee Services, and we're excited to have all three of you here to join us today. So since this conversation is today about the legal prohibitions on torture, Juan, I'd like to start with you to start with the international legal framework prohibiting torture. So can you give us a brief overview of the legal norms of international humanitarian law, human rights law, and customary international law?
Thank you. First, let me thank the American Red Cross, Kobe, and you, Christie, for the opportunity to talk about these topics. We wish they weren't as salient and as important as they are, but I'm afraid we're going to have to work very hard to defeat torture in the years ahead. Also a privilege and an honor to share the podium with Annie and with Alberto. The international legal framework, I think we should start with the laws of war. Torture is prohibited by the laws of war as a matter of customary international law, well received and admitted and accepted by all standing armies and all nations in the world. The Geneva Convention, specifically in Common Article 3, prohibit outrage against the personal dignity of prisoners. And the outrage against personal dignity is basically the technical terminology by which we understand torture in the context of armed conflict. And it's important that we use that terminology because it highlights the fact that torture can be both physical and moral or mental. Otherwise, the Geneva Conventions or the laws of war more generally, as far as I can tell, do not define what we mean by torture. So we understand it by reference to international human rights law. The International Covenant on Civil and Political Rights also absolutely prohibit torture under all circumstances, but also does not define torture. So we have to wait until the 1980s to have the United Nations Convention Against Torture that actually provides a definition that is the most widely accepted today. And it is any pain and suffering deliberately inflicted for the purposes of obtaining information or for punishing the victim or for several other purposes if they are discriminatory in nature. And so this pain and suffering has to be of a certain intensity and severity. And as I said, it has to be intentionally inflicted. In the definition, it's also established that it has to be inflicted by a state agent. But in international humanitarian law, that is not that significant because it's torture if it's inflicted also by irregular or unorganized participants in combat. And particularly insurgent forces, for example, are also strictly and absolutely prohibited from practicing torture. In terms of severity, there is a hierarchy of severity that because the Convention Against Torture also prohibits cruel, inhuman, and degrading treatment or punishment that generally is understood to be of lesser severity than torture, and also because it can be inflicted not intentionally but by negligence, and therefore inhumane prison conditions, even if nobody has designed them that way, are also prohibited. And it's important to say that both torture and cruel, inhuman, and degrading treatment are absolutely prohibited under all circumstances, and there's no emergency or specific situation that would allow for either cruel, inhuman, or degrading treatment or torture to happen under any and all circumstances, including, of course, war. The international legal framework, especially the Convention Against Torture, then establishes a series of consequences or legal effects of this prohibition. And the most important of which that I think applies also in the context of armed conflict is the obligation, affirmative obligation, to investigate, prosecute, and punish every act of torture. It doesn't have to be a part of a pattern of violations that would constitute crimes against humanity. Even a single episode of torture elicits this obligation on the part of the state. And of course, if torture is practiced in the context of armed conflict, it's a war crime. And the Geneva Conventions, war crimes also elicit the obligation to investigate, prosecute, and punish. I don't need to tell you that, unfortunately, this very clear and affirmative obligation is not widely observed by many, many states around the world, including, unfortunately, the United States. So I think the other obligations that emanate from the prohibition on torture include also the prohibition to deliver anybody to a place where he or she might be at risk of torture, the non-refoulement provision, and the obligation to deprive the results of torture from any legal effect in proceedings against the victim. That is what's called the exclusionary rule. So, in other words, states, if they obtain any information on the basis of torture, are precluded from using it against the person making the statement. In a thematic report that I wrote as a result of, in my capacity as a special rapporteur, I urged an expansive interpretation of the exclusionary rule, because states, we found out, were using the results of torture, the information obtained under torture, not so much in proceedings against the person making the statement, but also for other purposes, for exchange of intelligence, for example, for immigration decisions, etc. And so if the purpose of the prohibition of the exclusionary rule is to discourage torture from happening, we needed to close off all possible exceptions to it that would allow states to engage in torture and use the results of torture in some other ways. In other words, we needed to close loopholes for torture. And so it is important, I think, to interpret the prohibition with the object that it has in mind, that is the discouragement of torture. There's more, of course, to the legal framework, but I hope this begins at least to answer your question.
Thank you. Yes, absolutely. And to pick up on a couple of the examples that you've already started to give, and especially during your time as a special rapporteur, where you were able to travel widely and to talk with many different governments about different situations of armed conflict, what are some of the major violations of the prohibition against torture that you've been seeing, particularly in the context of armed conflict?
Well, in the context of armed conflict, torture generally takes a back seat to other violations. Unfortunately, widespread attacks on the civilian population, attract our attention much more than specific instances of interrogation of suspects under torture, for example. And so we tend, instances of torture and the redress for instances of torture in armed conflict tend to take a back seat to the urgent need to stop, say, aerial bombardment of civilian population or widespread killings of combatants that are hors de combat because they've surrendered or they have been captured or they are wounded. Unfortunately, those violations are much more severe and very frequent. But it's also true that torture happens as a matter of course. And in the correct interpretation of torture, they happen not only in the context of custody, that is when an enemy combatant is in custody, but it also, the cruel, inhuman, and degrading treatment certainly happens, for example, against the civilian population that is left without the means of survival, that is forced to be displaced, for example, and where the attacking forces don't generate the means to receive them in good health care and feed them. Those things can be considered violations of the prohibition on torture, but they're also by themselves violations of the laws of war more generally. In other words, war crimes. Yes, unfortunately, what I would also say is that because in armed conflict torture takes a back seat, the obligation that I mentioned before about investigating, prosecuting, and punishing torture also falls by the wayside. There's very little affirmative work in the sense of investigating, prosecuting, and punishment, and governments and forces around the world make up all kinds of excuses for not engaging in that crucial obligation to investigate, prosecute, and punish. I have to say that even in peacetime, the obligation to prosecute and punish torture is also not very well observed in practice. But at least in peacetime, we have the opportunity of having civil society organizations that push for it. We have independent prosecutors and judges that sometimes take this obligation seriously. And so there's more of a chance, at least, that we can make it happen. But in wartime, it's also the case that the obligation to investigate torture happens more exceptionally, as Kobe mentioned some examples, than than corresponding to the actual dimension and extent of the practice of torture in real life.
Thank you. That's a really important point. And I actually want to pick up on this idea of implementation specifically. And Alberto, shift to you to talk about some of the recent developments in domestic law on this issue. So in October of this past year, a Fourth Circuit Court of Appeals issued a unanimous decision allowing a lawsuit against interrogators who allegedly tortured detainees in Abu Ghraib to move forward. And they specifically rejected arguments that torture should be considered a political question beyond the capacity of the courts to resolve. And they also rejected legal theories proposed during the Bush administration that allowed torture, which you were quite vocal against. So in your experience, what signal does this make towards strengthening U.S. policy and practice implementing the legal prohibitions on torture?
Thank you, Christie, and thank you again. I'll echo what Juan indicated, my pleasure of being invited here by the Red Cross and by being on this panel with the three of you. Yes, indeed, the Fourth Circuit Court of Appeals decision in al-Nashiri was a watershed decision in terms of civil litigation on the issue of torture. At this moment, no civil litigant has been able to not only obtain redress for having been the victim of torture and having suffered those kinds of damages, but hasn't even been able to have a case tried on the merits as a result of a variety of doctrines that have been applied by successive administrations to block this kind of adjudication on the merits. The political question doctrine has been one of the principal barriers to adjudication of these claims. Fundamentally, court after court have held that claims brought by foreign citizens under a variety of theories, like for example, in the al-Nashiri case, the al-Shamari case, the theories were alien tort claims and also a variety of civil common law theories under which the remedies were sought. But in each case, the courts have found that political question doctrine barred adjudication of the cases. And political question doctrine, as the lawyers here would know, is typically examined under the Baker v. Carr sort of doctrine, which provides a six-factor test to determine whether or not the doctrine applies. The first of these factors is whether the matter in dispute has been essentially allocated to a politically coordinate division for disposition. And in this case, the argument has been that combat and military operations overseas has been allocated to the executive branch to handle. And one of the other categories of the examination is that not only is the principal responsibility within the executive branch, but only the executive branch has the necessary skill and expertise to be able to determine the kinds of issues of importance, and the courts lack the expertise necessary to adjudicate those kinds of issues. In the case of al-Shamari, this was one of the arguments, but the other argument which was raised by the court below in dismissing the case was that, in fact, the court lacked, quote, judicially manageable standards to decide the case. And this was one of the particularly outrageous elements of the lower court dismissal. What the court meant by saying that it lacked judicially manageable standards was that, as the court put it, there was a cloud of ambiguity, note the poetic quality of this phrase, that essentially prohibited the trial court from determining what the standards were to determine whether or not torture had been applied during this time in question. What the court must have been adverting to, although it wasn't specific in its dismissal order, was that the memoranda issuing from the Bush administration's Office of Legal Counsel and the Department of Justice created such confusion with respect to the standards, definitional standards for torture, that this court, 10 years later or so, was incapable of sorting out what the law was in order to adjudicate the case. This is one of the weakest elements of the court's dismissal, because courts have been adjudicating cases of torture or cruelty since almost the start of the Republic. And although this gets into issues of separation of powers doctrine, there was nothing which the executive branch could have done to trump what was congressional lawmaking in this area that could have effectively legally clouded the court's view as to what the definition of torture was before 9/11, after 9/11, and at the current time. Somewhat surprisingly, but almost all of us must feel gratefully, the Fourth Circuit Court of Appeal, in the fourth reversal of a case coming up from below from the same judge, unanimously, as you said, Christie, reversed the decision, remanded it back to court for adjudication, and it held that, first of all, political doctrine question did not apply if even if the actions complained of below were conducted by the military or under military control, if the actions below were unlawful in the first place. Had the actions complained of below had been lawful, then arguably political question doctrine would have applied so as to procure the dismissal of the case. But in this case, the Congress had adjudicated the law concerning what torture constituted. The allegations sounded in torture, and it is the province of the courts, not of the executive branch, to pronounce what the law is. This is the Supreme Court case which essentially determines what the prerogative of the judiciary is, upon which the court based its decision, and then quite properly remanded the case back down. This represents an opportunity for al-Shamari to be the first case that will be then tried on the merits by the trial court down below. So it represents a very welcome departure from earlier decisions that precluded access to the courts by litigants in this category of legal violations.
Absolutely, and I'm sure that we'll all be watching that case very carefully as it moves forward. Juan, in the last few months, the 2016 Presidential Memorandum on the Use of Force and National Security Operations, which is actually released in December, states that international human rights treaties may also be applicable in armed conflict. And it said in particular that the Convention Against Torture continues to apply even when a state is engaged in armed conflict. And so the memorandum also offers a comprehensive assessment of the numerous legal and policy-based limits on torture and the abuse of detainees, and many people think that it would be very difficult to reverse these policies at this point. But there's also been some criticisms of the explanation of the U.S. extraterritorial application of Article 3 of the Convention, which prohibits, as you mentioned earlier, non-refoulement, returning a person to another state where there are substantial grounds for believing that he or she would be in danger of being subject to to torture. So where does this memorandum leave the United States legally on this issue?
Well, I think the memorandum correctly states the international obligations of the United States with respect to the Convention Against Torture. And it's not insignificant because during the George W. Bush administration, there was an attempt to claim that all human rights instruments applied only within the territory of the United States. That is, that there was no extraterritorial application. In other words, that what United States agents operating outside of the territory of the United States could not be covered by the Convention Against Torture, by the International Covenant on Civil and Political Rights, and so on. Fortunately, the Obama administration changed that, and in that memorandum, but also in a presentation during the regular reporting to the Committee Against Torture, it took the position that the Convention Against Torture, the obligations of the United States under the Convention Against Torture apply both territorially and extraterritorially. That, I think, is very significant. I think we still need a pronouncement on all other human rights instruments. And finally, the memorandum that you quoted is very significant because some states, mostly I think Israel, take the position that once the state is in a situation of armed conflict, international human rights law is completely displaced, and it's replaced by the laws of armed conflict, international humanitarian law. That is a position that has been rejected by the International Court of Justice now several times, basically saying that international human rights law continues to apply even during armed conflict, albeit, of course, applying the principle of lex specialis. So, for example, if during an armed conflict you have to determine whether a loss of life is a violation of human rights law or not, you have to determine whether it's a combat situation, and in the combat situation you can shoot to kill. In a law enforcement situation, you have to explore other possibilities before shooting to kill. So obviously in combat, a loss of life is more governed by international humanitarian law than by international human rights law. Nevertheless, obviously combat situations, a situation of armed conflict involves many different situations, not only combat, but other situations. And therefore, I think it is the appropriate rule that in situations of armed conflict, international human rights law and international human rights law are of coextensive application, as it is said, and therefore subject only to the rule of lex specialis. I think with that memorandum, of course, it's going to be very difficult and unlawful under international law for a new administration to change that. But because, as I mentioned, the Bush administration had a different position on this, we should be prepared to see a return to these more specious ways of interpreting international obligations of the United States. I hope it won't happen, but if it does happen, at least now we're going to have some very good arguments to counter that from the perspective of civil society.
That's actually a great transition to the next point. And Annie, I'd like to ask you about this. The Senate passed the McCain-Feinstein Anti-Torture Amendment to the FY16 National Defense Authorization Act with very strong bipartisan support and was signed into law last November of 2015. And this made the U.S. Army Manual on Interrogations the standard for all U.S. government interrogations. And it explicitly prohibits waterboarding, forced nudity, and other forms of torture, and only allows interrogation methods expressly described in the manual. The amendment also prevents any future torture program from being authorized again, maybe Juan, to your point. But Annie, in the years since the amendment was signed into the NDAA, what impact have you seen that this has had on the prevention of torture in practice, or how have we seen this implemented?
Thank you, Christine, and just want to echo my fellow panelists in thanking the American Red Cross for inviting me to be part of this panel. It's an honor to be here. So in response to your question, the McCain-Feinstein Amendment didn't actually change the law as much as it codified the major elements of the executive order banning torture that President Obama signed in January of 2009. And so in terms of implementation, it didn't change current practice, though that is not to understate its incredible significance, I think particularly right now. What it did do is it ended the debate on whether waterboarding or these other forms of so-called enhanced interrogation techniques are blatant violations of a U.S. statute as passed by Congress. And you noted the bipartisan vote on that. In a vote of 78 to 21 in passing the McCain-Feinstein Amendment, the Senate really did demonstrate a return to what has been a long-standing bipartisan opposition to torture in the United States. And today, as we are 8 days away from inaugurating a president who, in his campaign, has both stated that he intends on day one to rescind all executive orders issued by President Obama, and also, while on the campaign trail, made several statements about supporting torture, about bringing back waterboarding, and worse. It's even more important that it's not an executive order that makes this clarification, but that it's actually in statute. And just in the last 72 hours, we've seen, when Jeff Sessions, the nominee for Attorney General, who has been on record as supporting waterboarding, testified before the Senate Judiciary Committee on Tuesday that waterboarding and other forms of torture are absolutely illegal. We also have heard similar statements from the DHS Secretary nominee, from the CIA Director nominee, and this also reflects a willingness, hopefully, on the part of the incoming administration to follow the law and to respect the law as passed by Congress. And we'll remain vigilant on it. Congress will need to continue to exercise oversight and the engagement of civil society, and this is important. But hopefully we'll be able to put this debate to rest soon.
Alberto, I also wanted to give you the opportunity to weigh in on the McCain-Feinstein anti-torture amendment, because I know that this is an issue that you've also worked very closely on for quite a while. So if you have anything that you'd like to add.
I think, as Annie indicated, the law has been strengthened against torture, or at least clarified. Torture was always prohibited. The Bush administration pretended that that prohibition either didn't exist or wasn't clear, or that it was overridden by commander-in-chief authorities. But whatever might be the answer to that dispute in the Bush administration, there's no doubt now, as Annie's indicated, as you suggested in your question, that the law prohibiting torture and cruel treatment is absolutely the law of the land. I'm quite concerned by how the Bush administration will, and President Bush himself will behave in this on this issue in the future, notwithstanding the clarity of the law. The number of his comments indicating that that torture was or is necessary in order to defend the country, and going further, his comments that in fact there should be no laws that bind American use of force in the fight against terror, and his desire to if the law exists, to modify it or to eliminate it. I have to assume that at some point in his administration he's going to act on those often stated desires or beliefs. There'll be obstacles, but I think the operating assumption, at least for me, will be that he will act on those assumptions in the future. There'll be significant obstacles. I think, for example, the nomination of General Mattis from this standpoint and on this issue is an excellent nomination. General Mattis' entire career has been about values and about the role that values and integrity plays in fielding not only an effective warrior, but an effective fighting force. The American military, despite deviation from this norm during the Bush administration, is very strongly this belief. Toby's comments, I think, reflected some of this, but the American military is a strong supporter of Geneva and a strong supporter that adherence to values is important not only to make an effective fighter, but also to protect the combat soldier from the disastrous psychological and moral consequences of combat. So the military can be counted, I think, upon to block any return, but with a president bent on implementing these policies, if a Republican-controlled Congress is less than vigilant about ensuring adherence to the law and then engaging in oversight on these kinds of matters, and sadly, with what the polls indicate are a majority of the American people supporting the use of torture in the fight against terrorism. The most recent polling by Pew Research Centers indicates that about 63% of the American people support this. That creates a situation such that if or when we suffer the next terrorist attack and the president exercises the power of his office to lead the country or try to lead the country in this way, then I think the norm against torture and the laws against torture will be threatened in that kind of situation.
I would like to actually pick up on your reference to General Mattis, who has been very vocal about his views against torture and prisoner mistreatment. And he's spoken of America as needing to hold the moral high ground. He said that failing to uphold important principles makes it easier for a soldier or a Marine to ask, what am I fighting for? So you touched on this a little bit, but I wondered if you could follow up and just talk a little bit about how strengthening prohibitions against torture strengthens our own military, and then how does it impact our leadership in the global community on this issue?
Well, let me get into a little more detail in response to your question on this. Why does the military support the rule against cruelty against detainees? Part of it is the utility of the Geneva Conventions, and Geneva Conventions has two utilitarian benefits. First of all, in most times of conflict, it promotes the reciprocal treatment of American captives by the enemy. So Geneva Conventions have been useful in saving and protecting thousands of American soldiers who've been held captive over many of the wars that this country has fought in the last half century or longer. Now, the Taliban, Al-Qaeda, and ISIS don't observe these reciprocal agreements. In fact, as Toby indicated, these groups have proudly indicated that they observe no international legal standards at all and disregard the notion of human rights in their conflict against their enemies. But then the second utilitarian benefit of Geneva is triggered, which is that in every war you have situations where enemy soldiers or soldiers are on the verge of being captured. Now, human nature being what it is, while there are some soldiers that will fight to the last bullet, regardless of the situation, because they believe so strongly in their cause, human nature indicates that most individuals would rather live rather than die. Most individuals would rather go back home and see their family or their children or their wives at some point in the future. And for those individuals, if they know the American soldiers will treat them humanely, they're less likely to fight to the last bullet than to surrender. So in that situation, where the reputation of humane treatment is known by enemy fighting forces, then the surrender of enemy forces is promoted, encouraged, and that has saved lives also in untold number of American wars. For example, German soldiers during World War II surrendered in droves to the British, Canadian, and American forces, but fought to the last bullet against the Soviets because they knew they would be ill-treated in Soviet captivity, as an example of how this situation works. Then there are the factors that I mentioned earlier before. The American military understands that treating captives detainedly is tactically and operationally sound. It's an advantage to the United States. Most recently, we saw this in Iraq, where the American military in 2006 determined that the number one and number two identifiable causes of U.S. combat deaths in Iraq in the year 2005 were number one, Abu Ghraib, and number two, Guantanamo, because those two symbols had such a powerful effect in the hands of jihadist recruiters in attracting foreign fighters and terrorists into combat against American forces in theater. So this is you can look this up in WikiLeaks. This is actually the conclusion based upon all source intelligence by the American military in 2006 as to the causes of American combat deaths. The last issue I won't deal with much, but I mentioned it earlier before, is the role that being true to your values plays in shielding the combat from the harmful psychological effects of combat.
Thank you. And one last question for you, just on the implementation aspect. There's near unanimous agreement among professional interrogators and intelligence leaders that so-called enhanced interrogation and other forms of torture and detainee abuse are not an effective or obviously lawful means to gather intelligence. So in your experience, what are some of the costs and consequences that the U.S. has faced as a result of these practices?
Yes, this is, as somebody who had never dealt with the issue of torture interrogation before going to the Navy, and then being confronted with the discovery that the American military was using enhanced interrogation in Guantanamo, which is where I first got involved in this issue. My first response was to oppose the use of that on legal and moral grounds. But when it became evident that the debate in the administration wasn't on those issues, and in fact the debate on the issue of torture is no longer on this issue in the country, because most Americans now are sadly not focused on the legality or morality of interrogation, but are focused on the utility. Will the use of torture make us safer as a nation, or make me safer as a citizen of the United States? And most individuals are now of the mind that this should be decided on utilitarian grounds. When I raised this issue with professional interrogators, in my case it was NCIS, I was surprised to learn that the unanimous opinion on the part of all these NCIS professionals who were expert interrogators, this was a core competency of the agency, as it is really in the military and in the civilian law enforcement world. So FBI also shares the same view. But their view is, based upon decades of experience, is that the most effective way to interrogate an individual, meaning the most effective way to get more truthful information faster, is not to engage in torture, but to engage in relationship-build interrogation techniques. This was the position that FBI took when CIA sought to supplant it by the use of torture. And unfortunately, the Bush administration never conducted a full-blown policy review of the facts and utility surrounding torture as an interrogation tool, but they accepted, or they assumed as true, the notion that torture is uniquely effective in providing truthful information faster, and it provides a degree of utility that is simply not found in other interrogation techniques. Most of the American public seems to believe this through the absorption of cultural messaging, such as movies and television shows like 24 and other kinds of shows. But the truth is that the data doesn't support that, those motions. Torture is not uniquely effective, and is not the most effective tool in interrogating terrorist suspects.
Thank you. And in just a second, I'm going to ask Annie to follow up on the issue of public perception on this. But since we do have Anna Nelson here from the International Committee of the Red Cross, who recently released the People on War survey that Kobe mentioned and is on your tables as well, I wanted to just ask Anna to give a very brief introduction to the section of the report. And Joe, do we have a microphone for Anna up here? There's a section in the report that does talk about American public perception here and how that has changed over time. So I wondered if you could just give a quick introduction to that.
Hello? Hi. I'm supposed to stand on this X here. So, indeed, thank you very much for the opportunity to share some of the results. Hopefully you all have copies. There are extra ones of them, of this report that the International Committee of the Red Cross has done in 16 countries involving 17,000 people, including 5,000 people here in the U.S. We asked them broadly different questions about their perceptions of the rules of war, but specifically about their positions on torture. And for those of you who aren't familiar with what the ICRC is and does, we are a neutral, Swiss-based agency. We're a part of the Red Crescent family. We're present in 80 countries around the world, mainly war zones. We visit roughly 800,000 detainees in around 100 countries every year, including those at Guantanamo Bay. Going back to the survey, when we look at the global statistics, 2/3 of those whom we talked to said that torture is wrong. But compared to 1999, the last time we undertook this poll, significantly more people in 2016 believed that an enemy combatant can be tortured to obtain important military information. In 1999, we had 66% of people saying that was wrong, and today only 48% agree. With regard to the U.S., our data was a little different from the Pew research that was mentioned. When asked if torture is wrong or just a part of war, 54% of Americans said it was wrong. So over half say it was wrong. But exactly 1/3 of Americans said it was a part of war. 13% said they didn't know or declined to answer. By comparison, 83% of Afghans and 73% of Syrians said it was wrong. So I would argue that the relatively good news is that over half of Americans think it's wrong to torture people. And so I'd argue on a moral level, half of them get it. But when you ask them if it's wrong to torture a captured enemy combatant in order to obtain important military information, you see a disturbing shift. On this question, only 30% of Americans said it was wrong to torture in order to get important information, while 46% said that was a part of war. And that reflected global perspectives. So I think, as was alluded to just a little bit ago by Mr. Mora, I think there's some different things that one can extrapolate from this. One might be that, there is this notion of the ticking time bomb. And so that, on a macro level, people seem to get that it's wrong. But when you drill down and offer them this scenario of obtaining important information, then their attitude changes. And again, I think I would agree that probably popular culture has played a role in that. Prior to 9/11, I think if we go back and look at the TV and movies that we saw, you would see bad guys torturing good guys, quote unquote, I use in carefully in air quotes, whereas post 9/11, with the arrival of the Jack Bauers and the Peter Quinns of Homeland, you see the good guys torturing the so-called bad guys. I think what I'd like to impart today is that from an ICRC perspective, torture is illegal. The prohibition of torture, as has been mentioned, and all forms of ill treatment is absolute everywhere and at all times. It is strictly forbidden by international human rights law, U.S. jurisprudence, the United Nations Convention Against Torture, and the Geneva Conventions, a body of law that the U.S. and its military have embraced since the 19th century. But importantly, it's wrong because it dehumanizes the victims and the perpetrators and the society that surrounds them. Torture can destroy the social fabric of communities, degrade a society's institutions, and undermine the integrity of its political systems. So our message, and this has been our message for a very long time, is that torture is morally reprehensible. Not just illegal, but morally reprehensible, and it should be permanently repudiated by all nations now and forever. Thanks. Anna.
So Annie, I wanted to follow up, based on the ICRC survey results, the Pew results that Alberto mentioned a minute ago. There's been some other recent polls done by the Constitution Project and Amnesty International, which also indicate that a strong majority of Americans, in addition to their views on whether torture should be allowed, they do, between 67 and 77% of the respondents said that they also think that the U.S. and international rules against torture should be strengthened. So what do these results tell us about the American public's knowledge and attitude towards the issue of torture, since we do have very clear laws and policies prohibiting torture? And what can we do to educate the American public on these rules?
So just want to say that I agree with many of the theories that Anna mentioned in terms of what the contributing factors may be to what has been this increase over the years in acceptance of torture by the American public, or a perception that torture can be justified in certain circumstances. And I do think the damage that was done by the United States, resorting to policies of torture and cruelty, followed by then years of people in positions of leadership defending those decisions simultaneously with a lack of accountability for those violations. I do think that that's had a significant impact, as well as the the messages that we're regularly receiving from pop culture that torture is necessary, torture serves the greater good, torture might be messy, but sometimes it has to happen in order to keep us safe, and those are very, very dangerous messages. I've been intrigued by this question related to the public opinion polling, in part because I have concerns with how some of the questions are framed in the public opinion polling, and I think that it's actually dangerous to have polls that are going out that in the question is embedded an implied efficacy of torture, or that in the question is embedded an implied kind of reinforcement of the misperceptions of torture that people may have. And so even to frame a question of use for obtaining important military information almost seems to imply that there is important military information to gain through that act. And so a person is perhaps in answering the question doing some kind of balancing, balancing in their own minds of what's worse. And so I think that we need to be cautious of that. And there may be some things embedded in the way that the questions were framed of the different kinds of responses that the Constitution Project or Amnesty International have gotten in comparison to the way that many of the Pew polls have been framed. Though undoubtedly, even with the Pew polls, we've seen that in 2004, when asked the exact same question, 43% of people said torture, can be justified, whereas in 2015, 58% of people were saying that torture can be justified. But one of the things that, and this may go to actually your question on education, that I found really intriguing about the ICRC survey was that there was a follow-up question that the ICRC asked, and that was that of those 46% of Americans who indicated that they believed an enemy combatant can be tortured in order to obtain important military information, 37% said that their opinion changed after learning that their country had agreed to ban torture. And I think that's actually pretty significant. And I would be really interested in seeing a follow-up question to that 46% that also said, so for example, upon learning that last week, 176 retired flag officers of all branches of the U.S. military sent a letter to President-elect Trump stating that torture is unlawful, unnecessary, counterproductive, violates our core values as a nation. Does that affect your opinion on torture? Those are the types of messages that really need to be out there, and things I'd really like to see reflected more in some of the public opinion polling.
It's a very, very interesting idea that could be a follow-up to that question. I did want to remind everyone in the audience, we're about to wrap up with the questions here. If you do have questions for the panelists, please do write them down on the note card and just wave them in the air. We've got a couple of volunteers that are going to come around the room and pick those up. And so just be thinking about that over the next couple of minutes. So Annie, my last question to you, I'd like to hopefully end on a bit of a high note. In your work with the Center for Victims of Torture, you all work with victims to achieve redress, and the Convention Against Torture actually does require state parties to ensure in their legal systems that victims of an act of torture obtain redress and have an enforceable right to a fair and adequate compensation, including the means for as full rehabilitation as possible. So in the work that you have done, in the overall strategy to eradicate torture, can you comment on the relationship between initiatives working on prevention, accountability, and redress?
Sure, thank you. And just to note, so the Center for Victims of Torture provides direct rehabilitation services to survivors of torture here in the United States, and then through programs and partners throughout the world. And just to note why rehabilitation is so important. At CVT, we see clients, coming in who, have, suffered, as a result of, experiences of torture, suffer from deep feelings of shame, guilt, humiliation. They felt there's been a loss of control. Some of the, symptoms that people are displaying, can include, sleep disorders, anxiety, chronic pain, suicidal ideation, and depression. And torture then and the impacts also affect not just the individual, but but their families, their communities. These consequences can also have long-term and multi-generational impacts that need to be addressed. And so I think just pragmatically, it's important to to address the rehabilitation needs that survivors may have. And there are also connections that can be made between redress and accountability if implemented properly, as I've heard Juan comment on in the past. A requirement to provide redress can serve a deterrent purpose, but also assisting victims, again, if these are applied and implemented properly, can help to establish and reinforce a climate of respect for the rule of law, good governance, and respect for human rights, and also in serving the individual for violations perpetrated against them, even in the absence of a criminal prosecution of the perpetrator. There's still a recognition that there has been an individual right that's been violated, and that there can be some kind of restoration for that individual. And so it's important as far as the recognition that these individual rights do need to be protected.
Great, thank you. And so please, if you have questions, raise them high so our volunteers can come around and pick those up. But the first question that we've received, and this is to any of you, the Geneva Conventions aside, what are your top 3 reasons for why engaging in torture is a bad idea? Maybe Alberto, we'll start with you on this one.
Yes, I think the one thing that we said about the U.S. use of torture in the Bush administration is that it necessarily meant that the right to be free from cruelty was no longer an inalienable personal right. If you can use torture against the 9/11 bombers, it's because those individuals didn't have the right to be free from cruelty, and if that's the case, then really nobody has a right to be free from cruelty. During the Bush administration, while this policy was in place, the United States position necessarily had to be that we're taking torture out of that basket of protected human rights and putting it back in the discretion of every state to determine on its own, using its own criteria, when it would use cruelty against individuals, at what severity, and for what kind of reasons. This alteration of the structure of human rights cannot be underestimated from the standpoint of how important this redefinition of rights would be. Our national vocation as a country, as a government, as a people, is to protect human dignity. And if an individual does not have the right to be free from cruelty personally, then human dignity is significantly diminished. And we don't protect human dignity, we don't advance human dignity by normalizing and institutionalizing the use of torture as a government, regardless of the reason, because that would be the long-term consequence. So I think that the damage to the nature of rights, the importance of human dignity, and then I'll mention one other thing that you asked me the question, I didn't really deal with this, but the consequences of the use of torture were significant when the Bush administration used them, meaning that the issue as to whether or not torture is useful to the country doesn't rest merely on the answer to the question, does torture work? Work meaning in the interrogation booth to provide some sort of intelligence, because the reality is that American use of torture had much broader policy consequences around the world. It fractured the alliances that we had with our member countries, because the use of torture is per se a criminal act in all those countries, and that had negative adverse consequences to the range of military intelligence and law enforcement cooperation with the war on terror that significantly degraded American capabilities in the war. It also constituted a strategic gift to our opponents. The reason why Al-Qaeda and ISIS and the Taliban use American cruelty as a principal recruiting tool today is because it is singularly effective in mobilizing support for them and opposition to the United States in ways that has reduced has led to American deaths and loss of combat power. So if we look at the question of torture, we have to ask the question, what are all the consequences? And if you go beyond the moral and legal analysis and look at public policy analysis, then the data from the Bush administration's use of it will indicate that this was bad public policy because it weakened the country, it made us less safe, and encouraged our enemies.
And Annie or Juan, if you wanted to chime in.
On that point, I wanted to reaffirm that, I agree with our ICRC colleague that our main argument is moral, our second main argument is legal. Torture is prohibited, legally prohibited because it is immoral. But since we still need to address the question of whether it works or not, I'd like to add to what Alberto very eloquently said a couple of other thoughts. One is that the Senate Select Committee on Intelligence report, which I hope someday will be published in full, at least we now know that it's not going to be destroyed because it is going to be preserved. But that report debunked all the myths about the utility of torture in very specific anecdotal ways. But I think that's one approach, and it's an important one, but it's not the only one, because there's something methodologically completely false about picking on an anecdotal evidence of having obtained useful information when you tortured somebody and then saying that therefore it's justified all the time, when you don't even look at the many times in which you may have tortured and didn't obtain any information, or you may have tortured and obtained completely useless or false information, and when all your law enforcement resources were scattered in pursuit of wild goose chases led to by the infliction of torture. So even scientifically, methodologically, these arguments that torture works because you got some anecdotal evidence that you got some truthful information is false. But also I think the analysis of the utility or inutility of torture has to be broader. And some of the things I won't just repeat what Alberto said, but coming from a country that in its time practiced torture extensively, and this is many other Latin American countries as well, not only Argentina, we have to reckon with the long-term consequences of using deliberate policies of torture. Consequences with respect to the confidence that people have in their institutions and in their government, consequences with respect to the credibility of if criminal investigations conducted by state institutions, consequences with respect to the cooperation of the public with law enforcement bodies. Because in fact, what we do is we corrupt institutions by telling them to torture. And then when we need them to deal with crime, when we need them to deal with terrorism, we have corrupt institutions that we can't, that can't have any credibility, that we can't really rely on, and we cannot trust them to protect us.
Thank you. And the next question, perhaps Juan, I'll start with you since this is an issue I know you've done some work on in your role as the Special Rapporteur. How are forms of torture that are less associated with intelligence gathering, such as the widespread use of sexual violence, treated differently in law and practice?
Well, at least from the perspective of international law, they're increasingly treated the same in law and in practice. It is true that we, meaning generally the international community, have not until recently paid enough attention to forms of violence against the person that we didn't immediately associate with torture because they were not in the setting of an interrogation, for example. And that includes various forms of violence against women and against children, and particularly sexual violence and abuse. But I think the international law increasingly treats it the same. And as a matter of definitions, there is really no difference, because there's no question that sexual assault inflicts the kind of pain and suffering of a moral and a physical nature that can only be defined as torture, of course, depending on its intensity. So the purpose is much less relevant to the definition. And besides, quite frankly, in my experience at least, sexual violence against women detainees is used also for interrogation purposes, for punishment purposes, for just denigration of the personality, and it's both a moral and a physical outrage that the law correctly so treats, increasingly at least treats in the same way.
Thank you. We've received, well, actually, did Annie or Alberto, did either of you wanted to add? Okay. We've received a couple of questions specifically asking, I think, follow up to Annie, your point about the culture and what American public opinion is here. So in your view, what would be the most effective means to educate the U.S. public that torture is always illegal, even in war, and to change the culture? Because as Anna mentioned, there's been TV shows and movies and different things that have raised awareness of this from a negative perception that we want to counterbalance.
I mean, I think if we saw more accurate depictions, in movies or on television of what torture produces or the consequences of it, that may go a long way. I could see really intriguing, dramas that actually show the story of real life interrogators and their quest for information that could be far more interesting than the very quick kind of plot lines that that imply that in order to get information fast, you need to take the gloves off, or what are the consequences to maybe perhaps from a legal perspective, or from a misinformation perspective, or to the individual who perpetrated the torture. What are consequences to them? If we saw more of that, I think that may help to chip away at a popular perception that torture is good, necessary, and important, and all the other things that we're seeing regularly.
I'll add to that in my experience, it's very difficult to address the horror of torture by using words. And this is something that took me years to recognize. And when you reflect on it, it's really the power of the Abu Ghraib photographs that brought home to the American people and most of the world the horror of abusive interrogations and abusive detention practices. Without those pictures, Abu Ghraib would not be Abu Ghraib, a symbol as we know it today. It would not have produced the shocking effect that it did in the United States and globally. So it's difficult to talk about torture because it's so abstract in comparison to the reality. The other thing I'll mention is something I learned from Centers for Victims of Torture, which is really the impact on the individual victim of abusive treatment. And even though I spent years dealing with this at the Pentagon, I didn't really understand the fragility of the human body and the human psychology until Doug Johnson, who was the former head of the center, explained to me through the research and the data which CVT had obtained through its clinical work with torture victims as to really the massive long-term permanent damage that even small amounts of cruelty can produce on individuals. And it's understanding that better, I think, would help the American people understand more the gravity of the practice.
Absolutely. And maybe to answer part of the education question, this is a topic that the American Red Cross has used as one of its thematic priority areas for the last several years, particularly in working with young people, who I think it's our job to really make sure as young people grow up that they know that this is illegal, particularly when they enter the military or are supporting military family members. This is something that we really, really want to reinforce. So the next question is, can you speak to the logical flaws in the ticking time bomb scenario, which is the singular hypothetical that is used to convince so many people that torture is okay because of the need to save lives? And any of you?
Well, let me try at that. I mean, first, the ticking bomb scenario is unrealistic. That's not the way torture happens. Let's just, say it in so many words. Torture doesn't happen that way at all. Second, as the Supreme Court of Israel said in 1999, it may be a plausible defense or even a mitigating circumstance if the torturer really, truly believes that he's pursuing a higher goal, or by committing something that he knows is a crime, by preventing a higher harm, a greater harm, then it could be used as mitigation of punishment. But the Supreme Court of Israel said it cannot justify a policy of administrative use of torture. In other words, you cannot say because in some cases you may be preventing a bomb from going off, then you can torture everybody that comes under your custody. But I also think that it's a very faulty argument because if you have a hardened terrorist who has planted a bomb and knows where it's going to go off, and he's so committed to his cause, however cruel and stupid that cause may be, why would he give you the information? Why would he not try to divert your efforts and send you, to different places where the bomb is not going to go off, to give itself time for the bomb to go off? I mean, it just doesn't even contemplate the rational, rational processes of someone who is being tortured. And I can tell you, people who are being tortured don't, abandon their rationality, or however twisted that rationality may be, just because they're being hurt. They continue to fight their struggle the way they see they have to fight their struggle. So why do we assume that a little pain will absolutely and immediately have the effect, the positive effect of finding exactly where the ticking bomb is? Just defeats me. It doesn't have any logic to it. And of course, I think we also need to compare with situations in which a rapport-based interrogation, and there are many countries that have explored this in depth and have adopted a humane way of interrogating and interviewing suspects in the criminal setting without violating any of the provisions of the Prohibition on Torture, and have better results. And they have better results even in real time. They actually get the information that they need. They don't have to wait months to get it. It's not true that torture is fast and swift and easy, and humane interrogation takes forever. It's just not borne by the experience of experienced interrogators around the world. And finally, I want to insist on the long-term consequences of engaging in torture. We just cannot justify torture on the basis of anecdotal evidence that sometimes you get some good information. We have to factor in all these other elements of what it entails to have a practice, an administrative practice of torture. And what it entails not only for the victim of torture, many of whom may be innocent, because once you have a program, you don't know how many people you're going to have to torture before you find the ticking bomb, right? So you torture everybody. But also the consequences on the faith of citizens on their institutions that I mentioned before.
I'll mention what my experience was at the Pentagon, because when I first came up with this issue, then I already thought through this scenario myself. I'd sit at my desk in the Pentagon thinking, okay, when I'm opposing torture because it's illegal, but as a policy matter, would I use torture to save 100,000 lives in New York City? And preliminary, my thought was, well, yes, probably I would. And then But then as I thought through this, I recognized that I might come to the same answer to save 10,000 people, and then 1,000 people, and then 100 people, and then one innocent person. I really couldn't find the threshold upon which I couldn't say that the logic of the ticking time bomb hypothetical was no longer ineffective. And for that matter, having come down to the decision that, well, philosophically, perhaps I could justify the use of torture to save one person, then it became clear to me that why limit it to foreign terrorists? Why not apply it as a law enforcement tool in the United States to solve criminal problems? What's the difference? And in fact, there is really no distinguishing difference. But then, having reached that level of thought, it occurred to me that if we were to do that, then this would be a very different country, and it would be a very different world in which we would normalize the use of cruelty throughout our society, and that's not where we want to end up. That's not the country we want to be, or that's not the kind of world that we want to help bring about.
Absolutely. Any thoughts, Annie? Okay. We've actually had a couple of questions asking about enforcement and accountability. Maybe I'll start, Alberto, with you on this question. Do you think it's appropriate or possible to hold prior U.S. leadership or perpetrators accountable for acts of torture that they've committed? And if so, what impact would you expect this to have on the U.S. and its engagement with the rest of the world?
For the reasons that Juan indicated, black letter international law and domestic law requires accountability for the commission of crimes. And the United States has not really held itself accountable for our use of torture in any meaningful respect. So for me as a lawyer, it is legally unthinkable that we would not hold ourselves accountable for having committed these crimes. By the same token, looking at the politics of this, I can recognize that it is politically unthinkable that the United States would hold itself accountable for the use of torture. Let's keep in mind that while the Bush administration authorized the use of torture, simultaneously it developed and deployed a system to shield account against future accountability. This was as important and objective when the use of enhanced interrogation was first proposed to the White House as the actual authorization for their use. That shield has been brilliantly effective in fostering a state of impunity for these kinds of activities, and that shield has been strengthened by Congress through a series of statutory enactments, created even greater difficulties against the possibility of bringing criminal action against the individuals involved in the decision. The Obama administration very purposefully sought not to inquire into accountability. President Obama's somewhat fatuous statement that he wanted to look forward, not backwards, as if justice isn't always rearward-looking, nonetheless deprived the momentum and took away the opportunity at probably the best time to engage seriously in an issue of accountability. Now, having said all of that, I think the fact that we haven't held ourselves accountable continues to inflict damage on the United States because it robs us of moral authority and it deprives us of the ability to exercise effective leadership in human rights issues and the development of international law. So we have to hold ourselves accountable in some sort of meaningful way if we're to be able to resume a leadership position. How do we do this? I think the answer is found in a speech given by retired Justice John Paul Stevens, talking about Guantanamo, really talking about torture. He adverted to what the United States had done with respect to the violation of the constitutional rights of the Japanese American citizens that were interned during World War II. And what he said was, look, we didn't prosecute those individuals responsible for the decision to intern them. What we did, maybe half a century after the event, was to acknowledge that the rights of these citizens had been violated, assuming national responsibility for this crime, and paying compensation to those victimized as a way of complying with the core elements of accountability. I think something of the sort might be politically feasible, although it still would be with some difficulty, meaning that the United States would not seek to prosecute those involved in the decision, but would then assume and declare national responsibility for having, in fact, committed the crimes of torture against these individuals, and then seek to bring about some sort of meaningful compensation for those who were victimized. For example, for those in Guantanamo who are being accused of the attacks on 9/11 or the Cole attack, one way to hold somewhat significant accountability would be to take the death penalty off the table in recognition of the fact that we had tortured these individuals. All of this might not be perfect accountability under the black letter of the Convention Against Torture, but I think it's significant and meaningful, and I think would help restore American respect for the law and for the principle of accountability that we need to regain.
Yeah, and I just want to note that in the earlier question on the relationship between prevention, accountability, and redress, this is, I think a perfect example of, areas in which, when there are legal barriers to criminal accountability, or there are the political barriers to criminal accountability, that you still have the victims, you still have the survivors of torture, and providing them with redress, with rehabilitation, can serve, as an accountability message, while also, tending to their needs and helping to fulfill their rights as victims.
Juan, did you have anything you wanted to add?
Well, only to say that the international standard is that the state has to pursue the evidence where it takes it, and that you have to prosecute those against you have evidence that they participated in any way in the establishment of the policy of torture and the actual execution of the policy. But it also has to be done according to standards of fair trial and due process. And so cutting corners is not the question, is out of the question, actually. What needs to happen is a regular process of investigation without obstacles, and leading to wherever it leads. And yes, I know it sounds incredible that it could even happen in today's moment, but there are examples around the world in which people who used to be all-powerful, untouchable people, have ended their lives, not only facing courts, but also, serving time for having ordered or committed very serious abuses. So, and those countries are better off for doing it. And so I think what sounds impossible today may not be impossible in the future, although that's not an argument for waiting. It's an argument for understanding that the demands of justice are always going to be there, and that hopefully at some point what sounds completely impossible for political reasons today may be possible down the road.
Thank you. That's actually, I think, a really great note to end on. And I did want to just mention for the audience, if you do have further questions on the accountability question, we hosted an event in November of last year on the specific question of government accountability for torture. And so that's available online on our YouTube channel and on our website, so you can feel free to check that out there if you'd like to hear a little bit more about that topic. So before I ask Kobe to come up and just give some closing remarks and to wrap up for the day, please join me in giving a huge round of applause and thank you to our speakers for their really, really wonderful contributions. So Kobe?
So I just want to, again, thank the distinguished panelists, and I also want to thank all of you for coming here today. It's an outstanding audience, and the importance of this work has never been, I think, clear. Thanks in part to some of this public polling, and of course the ICRC report. The decay of the public support and support for our rules of war, and the embrace of torture has never been more disturbing. The moral injuries to our nation and to our warfighters is just one price that this country has paid and will continue to pay. But thanks to the legal recourses that we've talked about today, thanks to the congressional actions that we've talked about today, thanks to the military leaders, as well as the educators and the advocates that vocalize and codify the opposition to torture, we now today have a new body of precedent, new legal foundation to help reduce this moral decay. And that's really our call to action. Our call to action is now, what do we do? What do we do now that we have this foundation from which to board spring from? I'm proud to see so many together with us today to take on this challenge and to help us reverse this trend in this moral decay. I want to end today by taking a special thank you to my team. And so I'd like Christie and the rest of our international humanitarian team please to stand up and or raise your hands that are here today. Thank you.